Yeah, very good afternoon to everyone. So let me take the attendance
Good
first.
afternoon, sir.
Asta Khandelwal, Aditya, Ankit, Jamima, Navya Singh, Preetam, Priyanshi Sharma, Samriddhi Tripathi, Saurabh Yadav, Shreya Dharan, Vatsal Rastogi, and Yashwardhan Tiwari. Rest will be joining. Okay, so
Good afternoon, sir.
yeah. So we have studied about the borrowings of the company and the debt, the capital structure of the company. So one thing is remaining, which is the borrowing powers of the company, to what extent the company can borrow, and what about the borrowing powers of the company. So we will be discussing that today. So borrowing powers of the company. So borrowing in order to run a business effectively and successfully, the adequate amount of capital is necessary. Now, in some cases, the capital arranged through the internal sources, that is by issuing the equity shares, or you can say by utilizing the cumulative profits, or you can, or if it is not adequate, then what you have to do? You have to go for with the external sources. So external sources can be ECBs, external commercial borrowings, debentures, bank loan, public fixed deposits, and all these type of things. Okay, so that is called borrowings. Borrowings is the external capital. So thus the borrowing is a mechanism which is used by the money, is in which the money is arranged through the external sources with an implied or express intention of returning the money back. So this is about the borrowings, you can say. Now, we have already studied, or we have discussed a lot in the last class itself, that why we should go for debentures, and you have come out with a very good discussion that debentures are utilized, debentures are required because it makes our total capital sometimes cheaper also, and at the same time it may make the venture very risky too. So totally depends on what is the extent of the capital you are having and what is the extent of your payment capacity. I've told you about the debt service coverage ratio, to what extent your debt is able to cover your interest, or to serve the debt. So how much profit is required in order to serve the debt? That is one thing which has to be considered. So there are certain things that how the company can borrow, the to what extent the company is interested with the borrowing powers. So the power of the, or if does the company, if it wants, it can borrow to whatever extent it can. Is it so, or what is the provisions of the Companies Act regarding giving the borrowing powers to the company's director? Because company will is a artificial person and it has to act through its directors, so they should not borrow the sum which has not been authorized. So actually there is some, because what will happen otherwise, the company will be held responsible and it will be held liable for it. And sometimes you do not have proper you can say what you call is you do not have a proper authority to take it up, or you can say you do not have proper accommodation to accept the loan or so. So that is to be considered while just giving it. So the power of the company to borrow is exercised by its director, who cannot borrow the more than the sum authorized. So the powers to borrow the money and to issue the debentures, whether it is inside India or outside India, has to be exercised by the directors at a duly convened meeting. So they have to convene a meeting for it, and in order to and from that meeting they take the powers to borrow the money for the company. Okay, so it may happen that the company may borrow the money and that company may run away. So in order to check this, and in order to just have the proper balance, and in order to you know have a proper legal things valid place, these are to be assured. So pursuant to section 179(3)(c) and 179(3)(d), directors have to pass a resolution at a duly convened board meeting to borrow the monies. So power to issue debenture cannot be delegated to board of directors. However, the power to borrow monies can, however, be delegated by a resolution passed at a duly convened meeting of directors to a committee of directors, managing director, manager, or any other principal officer of the company. Okay, so this is to be done only through a board meeting. So the powers of borrowing do not come as such from the top. Okay, so it has to be resolved and according to the and resolution must be passed in a duly convened meeting. Then only it will be valid. So resolution must specify the total amount up to which the monies may be borrowed by the delegates, that is to whom they are just giving the power. Often the power of a company to borrow is unrestricted, but the authority of the directors acting as its agents is limited to certain extent. Why? Because these people are the decision makers of the company, and these people can embrace the company's money. So to the extent they are given the power, they should not actually cross that limit, or they should not actually go beyond that limit. Okay, though the company is no one more thing is there over here. It is clear that the company is having a power to borrow unlimitedly, no problem. But again, if why it is so? Why it is so? Why a company is having a power to just borrow unlimited amount? Or is there any check and balance in this? Any one of you? Can company borrow to unlimited amount? Anyone? Or if it is so, why it is so? See, it totally depends on the person who is giving the money. If he wants to give the money, even if the company is already in debt, it is his risk and his will. So company cannot, just be restricted for that somebody is giving him loan, giving it a loan, and it should restrict it. So no law should restrict it actually. So the person who is giving it, if he feels that it is safe to give the money to the company, he can give it like that. Okay. So, for example, Section 81C of the Act prohibits the Board of Directors of the company to borrow a sum which together with the monies already borrowed exceed the aggregate of paid up share capital of the company and its free reserve, apart from the temporary loans obtained from the company's banker in the ordinary course of business, unless they have received a prior sanction of the company by a special resolution in the general meeting. Now, what is a general thing? So until and unless a company has, though the powers to confer to the company, the law has not at all conferred anything that you can have this much amount of loan only. So what it says that a company cannot borrow more than of its aggregate capital in the free reserve. Means whatever capital you have employed, you can borrow equal to that. Okay, but if you want to borrow more than that, then you have to take a special resolution. You have to pass a special resolution in the general meeting. Now general meeting is a meeting of body of shareholders. At the same time, the board meeting is a meeting of board of directors. So in board of directors, the decision to what extent the money can be borrowed will be delegated to either one person or to the committee of directors or to any key managerial personnel that we have just now seen in the previous section. But here in this section actually says that if you want to go beyond that, means if you want to go beyond the paid up capital, share capital, and the free reserves of the company, then you have to pass a special resolution in the general meeting. So it means that to the extent of paid up share capital and free reserve, the company is free to take loan provided it has authorized some of its directors to proceed further for taking the loan. Okay. So expression to section 181C provides that the expression temporary loans means loans repayable on demand or within 6 months from the date of loan, such as a short-term loan, or you can say cash credit arrangement, or you can say some overdraft facility or some discounting of bills. I mean, these all are the short-term loan or which are having seasonal in characteristics. But this does not include the loan raised for the purpose of financial expenditure of a capital nature. So except that all these loans are excluded. So this will not be included in the loans already taken. Okay, so this has to be considered as such. Okay, so temporary loans are the loans which are not to be considered in the limit of raising the money through borrowings. Okay, So it is further provided in the proviso to section 181C that acceptance by a banking company in the ordinary course of its business of deposits of money from the public repayable on demand or otherwise and withdrawable by a check, draft order or otherwise shall not be deemed to be a borrowing of the money by the banking company within the meaning of clause C of subsection 1 of section 80. So section 81C का जो आपको ये दे रखा है, this particular thing 81C, that it should not exceed the paid up share capital and free reserves. So if the company is of nature of a banking company, okay, so if a company is a banking company, its ordinary course of business is to accept the deposit from the public or the things which it has to do payable on demand or all that. So in that case, this particular limit will not be applicable for those demand deposit which it has actually taken on demand from the public as such. Okay, so these things will not be included in that. Please mind it, because it is in the ordinary course of business of such type of company. So it will not be included in that. Okay, so that is to be considered. Why? Because it is totally a different from what is the ordinary course of business. Okay, so it has to see it accordingly. Fine. So in this case, it is important at this stage to distinguish between the borrowing which is ultra vires the company and the borrowing which is intra vires the company, but outside the scope of the director's authority. So such borrowings may be the intra vires. Ultra vires means beyond the powers, and intra vires means within the company but beyond the authority of the directors. So here we have to understand what are unauthorized, or you can say ultra vires borrowings. Okay, so ultra vires borrowings where a company borrows without the authority conferred on it by the articles or beyond the amount set in the articles is an ultra vires borrowing. The articles can also, mention that this is the limit beyond which a company must not borrow the money. So beyond that, if the company goes, then it will be called as a ultra vires borrowing. Okay, so any act which is ultra vires the company is void. So any act which, if the directors are going with certain borrowings which are beyond the powers of the company, then such type of borrowing will be considered as void. It will not be considered as a valid one. Okay. So any act which is the ultra vires the company is void. In such a case, the contract is void, and the lender cannot sue the company for the return of the loan. The securities given to such ultra vires borrowing are also void and inoperative. Now, one thing comes over here: if the company goes for a ultra vires borrowing, as we have said that it is void. So what will happen to the money the company which the company has already received from such type of borrower? So lender cannot file a suit against the company for return of the loan. So what will happen in this case? What is your say? Yes, come on, Samriddhi. Do you have any
Yes, sir.
comments? What will happen in that case? So should we consider that company के तो मजे हो गए? It should keep on doing all ultra vires borrowings, because in ultra vires borrowing, lender will not be able to sue the company for the recovery of the money. What do you think, Aditya? Ankit? Anyone else? Shreya? Jamima? अरे भाई कोई तो बोलो, कुछ तो बोलो. Come on. चलिए मैं बताता हूँ. Now what happens in such a case? Though it is ultra virus borrowing, but at the same time there are strict provisions of the Companies Act in order to just have this. If it is so, if it is so, then the company may go into liquidation afterwards, and the directors will themselves will be responsible for paying off such loan, because it is something which is ultra virus beyond the powers, and knowingly, and directors must know their powers, and if they have gone beyond the powers, it means they have done something which will attract the lifting and piercing of corporate veil. Do you remember this? Guys, do you remember lifting and piercing of corporate veil? I told you.
Yes, sir.
So this will result to lifting. So आपने बोला ही नहीं यार. Lifting and piercing of corporate veil. This will attract all those provisions, and the directors will be held themselves responsible for it. Okay. So ultra virus borrowing cannot even be ratified by the resolution passed by the company in the general meeting. However, equity exists, equity assists the lender where the common law fails to do so, because common law तो क्या कहता है? Sorry, the common law, what common law is saying, that lender will not be able to recover the money, but equity is assisting. If the lender has parted with his money to the company under an ultra virus borrowing and is therefore unable to sue for the return or enforce any security granted to him, he nevertheless has in equity the following remedies. Now, what are the remedies? Remedies are where the company borrows without the authority conferred to it by the articles. So what will happen? Just a moment. Yeah. So it is having the following remedies. Just a moment. Yeah. So remedies are, first is injunction and recovery. Injunction is stay, to bring the stay from the government. So under the equitable doctrine of restitution, what is the doctrine of restitution? Restitution means to that the things which belongs to someone else be restituted to him, be given to him back. Okay. So the doctrine of restitution will be applicable, and he can obtain the injunction provided that he can trace and identify the money lent and the property which the company has bought with it. Suppose the company has bought some property out of the money which has been lended by the money lender, who has actually lended the money without any knowledge in the ultra virus borrowing given to him. So if he can actually trace that what money what the company has done with that money, he can actually recover the money with that property which the company has purchased. Even if the money is advanced by lender cannot be traced, the lender can claim repayment if it can be proved that the company has been benefited thereby. So one or the other way, if the company has been benefited, but the money cannot be traced because the company might have paid it to someone else to whom some loan might have been due. So the company one or the other way has been benefited, because the otherwise that particular lender would have filed a suit against the company. So such type of things has happened, the company is having, or the lender is having all the rights to recover his money. Next is the subrogation. Subrogation is something like that, to enter in the shoes of someone else. Okay. So it's like subrogation, where the money of a ultra virus borrowing has been used to pay off the lawful debts of the company. He would be subrogated to the position of the creditor, paid off, and to that extent would have the right to recover his loan from the company. For example, suppose 10 lakh rupees was due to company, due to A by a company. So B has actually given ultra virus loan to the company of rupees 10 lakh, and that 10 lakh has been given to that to A. So now what will B do? B will enter into the shoes and the position of the A, and he will stand in front of the company as if A is standing, and B will be having all the rights to recover the loan from the company as A. Okay, so subrogation is allowed for a simple reason that when a lawful debt has been paid off with an ultra virus loan, the total indebtedness of the company remains the same. So company is equally indebted in both the cases, whether to A or to B. So by subrogating the ultra virus lender, the court is able to protect him from the loss, while debt burden of the company is no way increased. because the company has not increased its debt burden. The debt burden is same, but this person will take the place of the person who has originally given the loan. Okay, is it clear to everyone? Are you understanding what I am saying?
Yes, sir.
Yes, sir. Fine. So next is suit against the director that I have already told you. In case of ultra virus borrowing, the lender may be able to sue the directors for the breach of warranty of authority, especially if the directors deliberately misrepresented their authority. Okay, so if there is a deliberated misrepresentation, then even the directors can also be sued. And here comes the provision of lifting and piercing of corporate veils, where the directors will be held responsible for their acts, not the company. Okay, these are certain cases. Ellie versus the Positive Government Security Life Insurance Company Limited, 1875-76. So this is one case. It was held that the articles are not a matter between the company and the plaintiff. They may either bind the members or mandate the directors, but they do not create any contact between the person who has lended the money to the company. Actually, articles only shows that what are the process of which the company is following. Okay. There's another case, Shuttleworth versus Cox Brothers. So I just remember at that time with Shuttle versus Cox. Okay, so you can play a badminton over here. So it was held that if the contract is subject to statutory powers of alteration contained in the articles, and such alteration is made in good faith and for the benefit of the company, then it will not be considered as a breach of contract and will stand valid. Now, what happened in this case was that the contract the articles of association of and the memorandum of associations were changed by the company for the company's benefit, and then afterwards the contract was entered into by the director. So the other party was having the old articles according to which they filed a suit against the company for the recovery of the money and saying that it is an ultra virus borrowing, but the borrowing power was increased and the new articles already had come into picture, and accordingly this particular contract which the company has made for the benefit of the company was treated to be a valid contract and within the powers of the company. Okay. Next is intra-virus borrowings, but outside the scope of the agent's authority or outside the scope of the director's authority. So I hope you do not have any problem till now. If you have, you may please tell me. Any problem, anyone?
No, sir.
Okay, should I ask someone some questions? Those who are not participating in the class. Lakshya Lakra. Is he there? Lakshya, are you there? Pritam Milan. Pritam Milan.
Yes, sir.
Yeah, what do you mean by ultra virus borrowing?
Sir, excuse me. What do you mean by?
Ultra virus borrowing.
Yes, sir.
What is ultra virus? कोरोना वायरस नहीं है, अल्ट्रा वायरस. What is ultra virus?
Sir.
हाँ जी, प्रीतम.
Sir. Sorry, sir. My mic was mute, sir.
हाँ, बोलो ना, please.
Sir, it is something that requires the legal authority, like something done on behalf of the legal authority.
गूगल किया है क्या?
नहीं sir. सर सच में नहीं किया.
Okay. Okay, it is going beyond the authority. Very good. So
Sir, like
yes, Sambhav Garg, what is ultra virus borrowings especially? Sambhav.
हाँ जी सर.
Yeah, ultra virus borrowing क्या होता है बेटा?
अल्ट्रा वायरस वही होता है जब हम when we borrow something which is exceeding the authorities given or which is specified in the AOAs.
Okay, where is the authority given to the company?
जी sir.
How will you determine that what is the authority of the company?
सर ये नहीं आता.
Shahid Chauhan. Shahid. Shahid Chauhan. सौरभ यादव. सौरभ तुम बोलो भाई.
Sir, yes sir.
हाँ बेटा, I was waiting for you to say something. So what is explain what is ultra virus borrowing?
Sorry sir, I didn't pay that much attention. I couldn't speak up.
Not expected from you, my dear. Chalo, anyways.
I'm really sorry for that, sir.
No problem. Just be attentive now. Okay. Shubham Singh Rana.
Yes, sir.
Singh.
Yes, sir. Yes, sir.
Yeah, beta, what is ultra virus borrowing?
Ultra virus borrowing is when someone borrows money which is beyond the power which is given to him.
Okay, according to section 181C, what is the maximum limit which doesn't needs any authorization by the company, or which doesn't need any authorization by the by the directors in general meeting of the company, which within which they can borrow? What is that?
The limit you're asking?
Yeah, limit. What is the limit?
पता नहीं sir, limit नहीं पता.
Though company can borrow unlimitedly, but
no sir, it's
one limit is there which is
actually जो होता है उसकी limit उसकी point out कर दी जाती है company की.
क्या point out कर दी जाती है?
यही कि कंपनी कितना borrow कर सकती है.
तो कितना borrow करेगी वही limit ही पूछ रहा हूँ तुमसे.
वो limit नहीं पता सर मेरे को.
हैं?
वो limit नहीं पता सर.
Anyone?
So to the extent of paid up share capital.
Yes, very good, Ishpreet. Yeah, what it was? I couldn't hear.
Sir, to the extent of paid up share capital.
And free reserves. Okay. So to the extent of paid up share, very good. To the extent of paid up share capital and free reserves, you can borrow the money without even asking the general resolution in the meeting of in the general meeting. Okay, so you have to pass a special resolution in the general meeting if you want to go beyond the paid up share capital and free reserves. Okay, thank you everyone. So what are intra-virus borrowing? Intra-virus borrowing is a distinction should always be made between the company's borrowing powers and the authority of directors to borrow. So where the directors the directors borrowed the money beyond their authority and the borrowing is not ultra-virus the company, such borrowing is called the intra-virus borrowing, but outside the scope of the agents means the director's authority. So sometimes suppose for example what will be the ultra-virus borrowing? Ultra-virus borrowing will be if you go beyond the paid up share capital and free reserves because you have not taken the permission from the shareholders in the general meeting. So if you go beyond the powers, then it will be ultra-virus borrowing. But suppose the limit is within the paid up share capital and free reserves. The limit is within that, and the directors are asked to just not to go beyond 50 lakhs suppose, and the within share capital and free reserves it is 1 crore. So 50 up to 50 lakhs that there is a authority of the directors, but they have gone beyond the authority and they have got issued, or you have taken your, or you can say they have taken the loan of suppose 60 lakhs. So their authority was 50 lakhs, but they have gone beyond the authority that is 60 lakhs, but this is within the authority of the company that is 1 crore. So they are still within the authority. So such type of borrowing will be called intra-virus borrowing, means within the powers but outside the scope of the agent authority was 50 lakhs. the director's authority was 50 lakhs. They have exceeded the authority and taken a loan of 60 lakhs. So the company will be liable to such borrowing if the borrowing is within the director's ostensible authority and lender acted in good faith, or if the transaction was ratified by the company. So company is having a power to ratify such transaction. But if the things are beyond the powers, ultra virus borrowing, then such borrowings cannot be ratified by the company and it cannot bind the other people, and the directors will become personally responsible. So if the company ratifies that, okay, whatever you have done, we consider it good. But this can happen only if the company is working within its authority. Okay, that is, suppose the directors has taken a loan of 1 crore 10 lakhs. So this is something beyond the powers of the company also. This cannot be ratified and the directors will be held personally responsible for this thing. Okay. Yeah. So where the borrowing is intra the company, but outside the authority of the directors, where the articles provide that the directors shall have the power only up to, suppose this is an example which I have just now given you. Suppose 100 lakhs and prior approval of the shareholder would be required to borrow beyond 100 lakhs. Any borrowing beyond 100 lakhs without shareholders approval, that is ultra vires act, can be ratified by the company and become binding on the company. The company would be liable, particularly if the money has been used for the benefit of the company. Here the legal position is very, very clear. The company has powers or capacity to borrow, but the authority of director is restricted either by the articles of the company or by the statute, and they have exceeded it. The company may, if it wishes, ratify, means make good whatever act has been done by the agent. It can make good, in which case the loan binds the company and the lender as if he has made a loan in the within the authority of the company. So this will be the legal position. I hope this is you are able to understand, because this is coming for the second time. I have already made you understand this. I have explained you. So is it okay with all of you? Any question if you want to ask me over here? Carry on with that if you want to ask any question. Now, this is a very famous case of Royal British Bank versus Turquoise. So, on the other hand, the company may refuse to ratify. Suppose, for example, the company has refused to ratify the acts of the agent, then what will happen? So, here the normal principle of agency will apply. The doctrine of indoor management, which was actually determined in the Royal British Bank versus Turquoise case, shall protect the lender, provided he can establish that he advanced the money in good faith. The third party who deals with the agent or means you can say the director, knowing that the director is exceeding his authority, has no right of action against the principal, means the company itself. So bearing in mind that the memorandum and articles are a public document, the contents of which are third party is deemed to know, he will obviously have no rights against the company if the agents has lack of authority is obvious from the reading them. Now what happens? These two documents actually are a public document, and everyone whosoever is dealing with the company is supposed to have knowledge of these documents. So when he is having knowledge of these documents, he must be having a knowledge of that what is the authority of the company. But a third party is not affected by a secret restriction on agent's authority, as the lack of authority is not clear from the public document and the lender cannot be aware of it from some other source. Therefore, the company will be liable. But in this case, if he is not at all able to, the lender is not at all able to know about it, or certain thing has happened which actually has been kept secret, or some secret restrictions on the agent authority has been done, in that case it will bind the company also. Okay, so this is what it is. So there is something which is called doctrine of indoor management. Means indoor management, you cannot hold anyone else responsible for inside management of the company as such. So this is what is being decided in this case. So we have studied two things: doctrine of ultra virus and doctrine of indoor management over here. Okay, so this is all about these types of borrowings and all you have already studied. Okay, so this actually covers a lot of portion which let me show you what we have covered till date in your syllabus, so that you will be having an idea of how we will be proceeding further with the rest of the things. Hope you are able to see this.
Yes,
See, we
sir.
have done up to from here: formulation, constitution of company, formation of company, memorandum articles, types of the companies we have done, capital and the financing of the companies we have done. Now, besides this, we have also done the borrowing powers. So this also we have covered. Okay, this all is covered till date. Now we had to take it in detail, so I have taken a lot of classes for just covering it off. But these things, other things which are remain like prospectus. Prospectus is a lengthy one, so this I will cover in one class, and membership also in one class it will take. Capital maintenance and all this is only half a class, which can be covered anytime along with those. Charges also will be, I'm taking the charges now itself. Okay, so this is what it is we have, because charges are part of your borrowings and all that, so I'm taking it now. So we will still be having some classes to do the revision, because this is, I think, our 12th class now, because one class at the time we missed when my son was detected positive, and I told you that it is something. Okay, so this we will be continuing. So let us just continue with the charges and finish off with the charges today. Yeah. Yeah. Charges. So what are charges? Anyone? Anyone a layman language, in a layman language, what do you call, what is it, what are charges? What are charges? Come on, anyone?
So penalty,
Sorry?
fine, penalty or fine. We can say charges or fine actually.
Okay, yes. Charges is something you are liable to pay, right?
Yeah. Yes, sir.
When you are bound to pay certain things, and these are certain charges which you are paying. Suppose you have taken some ride on a taxi, then you have to pay some charges, right? And sometimes when we are taking the, you can say, the service from someone, then we will ask, we ask that, okay, how much will you charge? Okay, so it's like that. Fine. So we will study this. This is actually with context to making a loans a secured loan. Okay, when you are charging someone, means you are actually putting a charge. You something. So now one more meaning of charge, one more layman meaning of charge is something which is related to, that you are charged enough, right? बैटरी चार्ज करते हो कि नहीं करते हो मोबाइल की, अपनी खुद की भी करते हो. Okay, so that is what the charge is. So when you are charged up, then you are able to do the thing whatever you want. Okay, so this is about creation of charges. So definition of charges is given here. Charge is an interest or lien created on a property or assets of a company or of its undertaking, or both, as security, and it includes mortgage. Actually, this was a one statement. This entirely was a one statement only, but I have broken it down into different. You can say 7 points are there over here. So charge is a interest or a lien. Okay, charge is a lien means lien. What is a lien? Anyone of you? Lien is a right which you exercise on property of other in order to enforce your claim on it. Okay, so it's a interest or a lien. That is created on a property or the assets. So it is created on assets. So of course now here we can say it is a lien on the property of a company or any of its undertaking as a security, and it includes mortgage. So it is very clear with this definition that if you are going to put the property of a company on mortgage, then to whomsoever you are giving the property, there will be a charge on it. There will be a lien on the property against the loan which has been given. So charges are the things which actually make the debenture secure. Okay, so security of debenture totally depends on the charges. So according to section 216 of the Act, the charge means interest or a lien created on the property or the assets of the company or any of its undertaking or both as a security and includes mortgage. So this also includes mortgage. So charge is created when security is given for securing loan or debentures by way of a mortgage on the assets of the company. So whenever you are just putting your assets to the bank will create a charge on the assets on those assets, and before you have paid off the money, you cannot actually sell off those assets. So there will be lien of those who have actually put your property on charge and those who have given you a loan. So charge also includes a lien and is an equitable charge whether created by an instrument in writing or by deposit of a title of deed. So the title of deed, or you can say the registry of the property, is to be kept by the bank, and the bank will create a charge on it and bank will endorse that this is being charged. So there was a case of Dublin City Distillery versus Doherty. So this was one of the things where the charge was created. So two types of charges are there: fixed charge and a floating charge. So fixed or a specific charge is a charge is called fixed or a specific when it is created to cover the assets which are definite or capable of being ascertained and defined at the time of creating the charge. For example, normally you can say that fixed charge is on the fixed assets of the company, whereas the floating charge is on the floating assets of the company, that is the current assets of the company. Okay, so this is very easy to understand. So example, land and building or a plant and machinery, these all are the things which can be determined at the time of creating the charge. That's why it is called fixed charge. So a fixed charge is a security in terms of certain specific property, and the company gives up its right to dispose of that property until the charge is satisfied. So company itself is giving is actually you can say disposes of the right. So normally what happens, whosoever is a owner of the property is also having all the rights to dispose of the property of the company. So here what is going to happen, the company is going to just forego that right, that until unless I will pay back all the money, I will be having no right to dispose it of. So in the winding of the company, a debenture holder secured by a specific charge will be placed in the highest ranking class of the condition. That's what I told, that these are the charges which actually makes a debt secured one. So these are the charges which actually secures the debts. Okay. Now, what is a floating charge? Floating charge is not attached to any definite property, but it covers the property of a fluctuating time. Just for example, stock in trade, okay, like debtors. So there can be charge on stock in trade and debtors also. A floating charge is peculiar to companies as a borrowers. Okay, so floating security is not a future security. It is a present security which presently affects all the assets of the company expressed to be included in it. So advantage of floating charge is that the company may continue to deal in any way the property it has been charged. The company may sell, mortgage, lease such property in the ordinary course of business if it is authorized by its memorandum of association. So the creation of floating charge is beneficial for the company. Why? Because after creation of floating charge, so the assets of the company can be normally in its dealing. So fixed charge is actually a higher, you can say, a position of charge rather than a floating charge. Okay. Next is your crystallization of floating charges. Now, as I've told you, the floating charge is something like which is floating. Okay. So floating charge is something which is actually not freezed, or you can say floating charge is like a water. Okay, and the fixed charge is like a ice. So what happens, the company actually, when the charge is created, or you can say the floating charges is there, so when the things are moving, you cannot just catch hold of them and determine the things as such. So what happens, then the company has to go for the crystallization of charges. So floating charge, before it is actually enforced, it is to be crystallized, or you can say the water to be converted into ice, and then only you can just hold the ice in your hand, or you can say. Okay, so the company has to crystallize the floating charge before before doing anything. So floating charge attached to the company's property generally remains dormant till it is crystallized or becomes fixed. So company has a right to carry on its business with the help of its assets over which the floating charge has been created till the happening of the event which determines the right. So what is the happening of that event? Unless the creditor to whom in whose favor the floating charge has been created, if he doesn't take the action, what will happen? If he doesn't take the action, then the company will then only the company will be able to do the things. If the action is not taken, then the company will not be able to do anything. If the action is if is taken, that is the creditor has raised his voice that okay, my payment of interest has not been done, my payment of debt has not been done, the company has bounced one installment. So until unless these things happen, the creditor will make a noise, then only the crystallization of charges will happen. So a floating charge crystallizes and security become fixed in the following cases. Number one, when company goes into liquidation. Secondly, when the company ceases to carry on its business. Third, when the creditors or the debenture holders take steps to enforce their security, that is, by appointing a receiver to take the possession of the property charged or on happening of event which is specified in the deed. So these are the four things which actually crystallizes the floating charges. Okay, so by crystallization of floating charges, what will happen? The company will stop dealing in those assets. So whatever assets will be there in the godown of the company, it will all be freezed and the money will be realized on those assets. Okay. In government stock investment company limited versus Manila Railway Company Limited, the debentures were secured by the floating charge. So 3 months interest became due, but the debenture holders took no step and the charge did not crystallize but remained floating only. The company then made a mortgage of a specific part of its property. Held the mortgage was having a priority, the security of the debentures remained merely a floating security as the debenture holders had taken no steps in order to enforce their security. So had the debentures would have taken some steps, then the situation would have been different. In that case, the company would have not been having no authority to deal with the security in any of the deal with the stock in any of the cases. But here, the who has taken the action first? The company has already mortgaged that particular floating. You can say the floating goods to someone else. Okay, so that is what it is. So effect of crystallization of charges on floating charge, what will happen? So on crystallization, the floating charge converts itself to a fixed charge on the property of the company. So it has priority over any subsequent equitable charge and other unsecured creditors. Preferential creditors who have priority for payment of the secured creditors in the winding up get priority over the claims, the debenture holders having the floating charge. Okay, so as soon as the crystallization happens, the person in whose favor in whose favor this charge has been created at the time of giving the loan will become prior and he will be able to receive the money before anyone else. Okay, next is your postponement of floating charge. The floating charge is postponed in the favor of the foreign person if they act before the crystallization of the security. So for example, there is a landlord who distrains for the rent, a creditor who obtains a garnishee order. Garnishee order means the recovery order. Order absolute means absolute recovery order he has got. A judgment creditor who attaches the goods of the company and get them sold. But if the goods are not sold, the debenture holders take the action in the meantime, and the floating charges has a priority. For example, so means if so if the no what will if the crystallization is not happening, if the crystallization doesn't happens, then the charge become postponed in favor of those who have taken the action. Okay, so the employees of the company as well as the other preferred creditors in the event of winding up. So employees of the company will ask for their remuneration, their salaries and all that. Okay, so if the charge has not yet been crystallized, so they will get the priority. Okay, so it is very, very important for the shareholders to crystallize the charges. Okay, when the time of the crystallization comes. So next is the supplier of the goods of the company under a hire purchase agreement. So he will get, you know, the right on the property which he has hired, which on which the hire purchase has been there. Okay, so they all will get the priority over others. And when the crystallization doesn't happen, the charge gets postponed in favor of those who actually take action against the company for enforcing their debt. Okay, so restraint on the power to create charges with priority to a floating charge. So as a floating charge allows the wide powers of the company to deal with the property subject to the floating charge, it is common to insert a clause restricting the powers of the company to create a charge with the priority or pari passu with it. Pari passu means as good as or equal to it. So thus, if the company creates a mortgage in favor of any person who has notice of the floating charge and restriction, such person ranks after the floating charge, but a person who obtains a valid mortgage can show either that he was not aware of the existence of the floating charge, and that though he was aware of the charge, he was not aware of the restriction, is entitled to priority by virtue of the legal state. Furthermore, where the specific charge is created expressly subject to a floating charge, the specific charge is postponed as from the date when the floating charge crystallizes by the appointment of a receiver. So if there is a restraint or restriction, and though this restriction is not at all you can say applicable, but if the other person to whom the company has gone with you can say remortgage or has transferred the goods in presence of the charge, if the company is having a reason of belief in such a case, what will happen? Then the other person has to prove that he was having no knowledge about such type of restriction, so he will be treated at par with such charges. Any problem here?
No, sir.
Okay, fine. Great. So invalidity of a floating charge. A floating charge remains afloat until a winding up commences, unless it has already been crystallized through the intervention of the debenture holders or the creditors. Also, a floating charge is valid only against the unsecured creditors, whether in a winding up or otherwise, but Act prevents unsecured creditors to get priority over the creditors by obtaining a floating charge when he learns that the company's liquidation is imminent. Okay, so what will happen though if the charge has not been activated? In such a case, it can be in favor of the unsecured creditors, but unsecured creditors cannot supersede the powers and get the charge in its favor until and unless it is not at all postponed. Okay, so according to section 332 of the Act provides that a floating charge on the undertaking or property of the company which is created within 12 months immediately preceding the commencement of the winding up proceedings of a company shall be invalid. For example, a company, everyone knows that a company is going to be, you know, liquidated. So because the company is going to be liquidated, the company directors, they become very smart and they try to create the charge. Yes. Yes, my
सर
dear.
मैं ये कह रहा था अभी 1:30 हमारी क्विज है सर.
Okay. So what is the time?
1:10 सर.
सुबह 1:10.
So बेटा अब 2-3 मिनट तो मैं लूंगा ही ना. This is going to be over. Not much is remaining.
So actually, we haven't taken our lunch and we have to give quiz, then continuous classes we have.
Okay, you want me to relieve you before that?
Yes, sir.
Is it so?
कंटिन्यू कर लेंगे सर.
Sorry?
We'll continue this topic in the next class, sir.
No problem at all. But is there somebody is having class at 1:15?
Not 1:15, sir. 1:30.
1:30 you are scheduled with another class
The
regularly.
quiz, not class, sir. The quiz.
But why people are not taking quizzes in their own classes?
पता नहीं सर, हम भी यही कह रहे थे.
What the hell? Who is this? Who is taking this?
कौन है?
Nishu ma'am.
Nishu.
Nishu ma'am.
No, quizzes should be taken in the class itself. Means you are asking for an excuse, and you please tell the teacher to take the quiz in their own classes. Okay, I will talk to Nishu madam. Okay, so not now, but you are as it is being scheduled now. You can please proceed further with it, and afterwards I will have a talk with her. Okay. So at least not after my class here, because you guys are otherwise, So no problem, guys. It is okay. We can continue in the next class itself. I think we are going and doing well also. So in this week we will be having a quiz too. Okay. So I will keep my quiz in my own class or after my class itself. It will take only 5 to 10 minutes to just go with that quiz. Would that be okay?
Yes, sir.
Fine. So let me just take the attendance. We will continue with this tomorrow and onwards.
Excuse me, sir.
Yeah.
So could you possibly schedule your quiz maybe next Monday? Because we already have 3 quizzes lined up this week.
No. Not at all.
Okay,
This
sir.
will happen in my own class, and you don't worry. You will be able to answer all the questions. It will not be that much, because the things which have been made clear, and before that I will take you to the revision, my dear.
Okay, sir.
Sandeep? I will take you to the revision, and then only I will expose you to the quiz. Don't worry about it. Okay, Sanya?
Yes, sir.
Yeah. Don't worry about it. So let me take the attendance. Asta Khandelwal. Just a moment, where the cursor has gone. Yeah. Attendance please. Asta Khandelwal, Abhigyan Gupta, Aditya, Ankit, Anshul Goswami, Arpan Mishra, Ashutosh Maharshi, Ashmit, Ayush Bothra, Ritik Bhardwaj, Ishpreet Singh Walia, Janvi Singh, Jamima, Karan Agarwal, Kaushal Agarwal, Lakshya, Meghna Dhuria, Naman Jalan, Naveen Chandlani, Navya Singh, Neha Singh Rathore, Priyam Milan Laskar, Priyanshi Sharma, Sambhav Garg, Samriddhi Tripathi, Sanya Kanwar, Sarvansh Sinha, Saurav Yadav, Shahid Chauhan, Shara Khan, Shreya Dharan, Shubham Singh Rana, Tushar Khandelwal, Vanshika Sunil, Vatsal Rastogi, Yash Chaudhary, and Yashvardhan Tiwari. So thank you guys for being with me and having this class, and have a nice day and all the best for your upcoming quiz.
Thank you, sir.
Thank you, sir.
Have a great
Thank
day.
you,
Guys.
sir.
Yeah. Bye bye. See you.
Bye,
Bye,
sir.
sir.
Bye,
Bye.
sir.